This local law is intended to prohibit natural gas exploration in the town of New Hartford. It was not initiated by a petition of residents, but rather by the board itself on its own motion to come forward and look at this. The law itself is drafted in the same format as the town of Dryden's ordinance, which has already been upheld by one court in the state of New York. There is one change that I would suggest that we make to this, and that is on section 3, paragraph 5, invalidity of permits. This section provides that the town would have a right to negate or supersede permits that had been issued by the state or federal government. In the Dryden case, the court specifically held that the town does not have a right to override the other municipalities, being the state and the federal government. Further, on our seeker comments, when we sent it out for review to all interested agencies, one of the agencies did respond that they were familiar with that decision of the town of Dryden and that that paragraph should be deleted because it's already been held not to be enforceable by a court in the state. Lastly, what I would like to do is just call everyone's attention, as well as our board, to the 2007 Comprehensive Plan, which was adopted, and that specifically has a section under Article 3, Environmental Setting, 3.2, Major Environmental Features. Talks about the fact that 52% of the town of New Hartford is classified as a national prime farmland, and an additional 13% of farmland is deemed to have statewide significance. Further deals in section 4.2 with concerns over water and ongoing protection of aquifer areas. It as well suggests that we adopt groundwater and water quality protection regulations. In addition, I think it important that we look at 4.3 dealing with air, 4.7 dealing with transportation, 4.8 dealing with noise and odor. Now, this is a public hearing. The board is here to hear your comments. As we said, the matter has as well been referred to the planning board for their input. We don't have that yet, and accordingly, there will be no action taken on it tonight until we receive the planning board's suggestions. Local law deals with natural gas exploration and extraction. If you read the definitional sections, which I'm sure you have, natural gas and petroleum extraction means digging and drilling of wells for purposes of extracting and developing and producing natural gas. There was a comment that it doesn't say hydrofracking. Well, hydraulic fracturing is one of the means that's used to extract natural gas. So this is not limited to that. It's much broader. If somebody comes in and starts drilling for natural gas, this would apply. I think the other comment dealt with if somebody had a storage tank of some kind, and if you look at the definitional section as to natural gas and or petroleum support activities, I think that's where that comes from, and it says shall mean the construction, use, maintenance of a storage or staging yard, water fluid injection station, water fluid gathering station, natural gas or petroleum storage facility, which is what I think that gentleman was talking about, or natural gas or petroleum gathering line, venting station or compressor, and then you've got to read on, associated with the exploration or extraction of natural gas or petroleum. So it's keyed in to extraction, and it's very broadly worded so that you kind of cover every base. That you can't even, if it's part of extracting it, you can't have the storage, you can't have the line, you can't have anything. So it's intended, and I think that's why the court, in deciding in favor of the town of Dryden, felt that this was so well drafted, because it is pretty clear-cut, it is pretty broad, and it is pretty decisive. There are no real loopholes in it, and they reference the fact of the Court of Appeals decision that held that municipalities have the right through their zoning ordinance to ban natural gas exploration.
they haven't given us
No.
their comments yet.
No.
So we're deferring action until we get the planning board.
Yeah. Reimer, do you know when the next planning board is?
I would assume that we'll have one in November.
Yeah.
You know,
I think it's maybe the second week in
second week.
November.
Second week in November.
At such time that we get the comments from the planning board, that's the last one?
Yep, that's
Last
it. We have all the
we've got
other
everything else.
comments. And everybody's aware, we're deleting that paragraph 5, invalidity of permits, based upon the decision in the Dryden case. As I indicated, there was a question raised by Mr. Corey. I think he sent an email to some people. I followed up with a conversation with Dave Everett, who is the attorney with Whiteman Osterman, who's very much involved in the litigation process of these cases. And it was his suggestion, based on the Dryden decision, that paragraph 5 be deleted, because the Dryden case was critical of that paragraph. The rest of the ordinance was upheld, except for that one paragraph.
Okay, so at such time, at the next board meeting, when we have the comments from the planning board, then we'll bring this up again, we'll vote on it.